we have a panel 3, reparations issue. It is a great honor to announce the participants on behalf of Chef de Cabinet of the ICTY President, Alexander Zervos, Deputy Chief of the Cabinet, on behalf of IOM, Mr. Peter van der Auwert, Henning Wildensen, who is a General Legal Advisor and Chief of Legal Office of the European Union, Mr. Thomas Osorio, Advisor for Rule of Law and Human Rights of UNDP, Jürgen Schur, Legal Advisor, Redress, UK, Andrew Main, Representative of UNHCR of Bosnia and Herzegovina, and Sandra Orlovic, Executive Director of the Fund for Humanitarian Rights, and the moderator of this panel will be Jonathan Sisson, Regional Advisor of the Program for Facing the Past from the Section for Human Security, Ministry of Foreign Affairs of Switzerland. Thank you.
Good afternoon. It's been a long day. I hope you're not too exhausted by the discussions, the very intense discussions that have been taking place. I would like to introduce the topic of our panel this afternoon in a few words, and I've been informed that we should speak slowly and softly because of the interpreters. They've also had a long day. Let me say, yes, a panel on reparations. As you know, this is a conference commemorating the 20th anniversary of the International Tribunal for the former Yugoslavia, Criminal Tribunal for the former Yugoslavia in The Hague, which was established in 1993, really under the premise of the primacy of justice in addressing the terrible crimes that were committed and were being committed at the time when this tribunal was established. It is also in the year of 1993, 20 years ago, that a special rapporteur at the subcommission of the UN Human Rights Commission in Geneva presented his first report on the issue of the right to reparations. This was Mr. Theo van Bilven. Some of you might know him. Presenting his report on the right to reparations. This report then was developed further within the UN system, and eventually in 2005 became the basic principles on reparations. And this is really the founding document, one of the primary documents establishing the right of victims to reparations. And we'll be hearing more about that document this afternoon. So actually we're looking at a long history, not only with regard to the issue of justice and the judicial procedures as we heard about during this conference, but also with regard to the issue of reparations. This afternoon, we've gathered a number of experts and resource people around this table as panelists to present some of the reflection that has gone on around the issue of reparations in former Yugoslavia in Western Balkans, in particular with regard to a report which was commissioned by the ICTY and carried out by the International Organization on Migration. And the author of that report is here together with his colleagues from that office. So we'll have an opportunity to learn more about the specific recommendations presented in that report commissioned by the ICTY. Yesterday, in the first day of this conference, we had a working meeting taking advantage of the presence of experts at this conference and resource people. We had a working meeting to reflect around the issue of reparations, outgoing from this report, but not only focusing on this report. And we are going to share with you some of the outcomes and findings that were formulated at that working meeting yesterday. We have a rapporteur from that session yesterday who will present those findings. And then we would like to engage on a discussion at the panel on a number of issues outgoing from the working meeting yesterday in connection with the report, but perhaps more importantly, outgoing from reflections from this audience here this afternoon. And what we are proposing to do is not to begin with the panel discussion and presentations, but to begin with you. One of the important issues raised in connection with this report was that any program on reparations, any comprehensive program on reparations should be developed with a victim-centered approach. We've heard that there are a number of representatives of victims' organizations in this room. A number of you are working with victims' organizations or are victims yourselves. We would like to give you first the opportunity to share with us your experiences with regard to the issue of reparations and what you think is needed today in the area of reparations. So, what do victims want with regard to reparations? Let's hear from you. What do victims want? What do you think should be done with regard to the issue of reparations? So let's begin with the audience, please. 10, 15 minutes, initial responses. Yes.
Thank you for changing the course of order. My name is Dahirovic. I'm the president of Association of Victims and Witnesses of Genocide. What do victims want? Several things when we speak about reparations. Probably we speak a lot about material compensation, money that the victims should receive. However, this is only one element necessary for the victims to be adequately involved and included in life together with the entire community. What's more important, in my opinion, than the material compensation is lustration, which has been neglected in Bosnia and Herzegovina and failed. Later, it was given up altogether. Most of those who took part in the crimes, they take part in authorities, starting with local communities to higher level institutions, which unfortunately is not something that would provide victims with greater satisfaction and enable their adequate contribution in society. I have an example from Prijedor. I'm not sure if anyone is present here. A person who was a guard of one of Prijedor prisons now works in municipality on cases of assistance to civilian victims of war and resolving their status matters, which brought victims into a situation that they do not want to address such institution for any assistance because it is humiliating to them, let alone seeking getting any rights from them. And if any victim decides to proceed, then it is a victim of many manipulations, and certain arguments are made up in order to detour the victim, which in my opinion is very important matter, which would be necessary for further process. I want to go back briefly to non-material damage issue. And fortunately, when we speak about reparations, I'm sorry not to see Mr. Nešković from the Association of Camp Inmates, because he is the first who, I beg your pardon? But you're here, but you're not among the panelists. That's what I meant. I'm aware that you are sitting in the audience because the Association of Camp Inmates of BH is one of the first NGOs that launched mass claims for compensation. And I repeat that the representative of the association should have been up there to present all the facts that were drawn based on the project over the 5 or 6 years, which is the time for how long this project has lasted. And he was the one who could have informed you what are the problems and what are the obstacles that hamper the victims to exercise their rights. These are deficiencies.
Perhaps we could talk to this gentleman. We give him the word? Would that be possible? No? The issue is, what do victims want? What do they need? What are the issues today? I'll repeat for you.
I wasn't listening to the interpretation. I will introduce myself, Jasmin Mešković, president of the camp inmates in Bosnia and Herzegovina. I will not take up a lot of your time. Reparations are a very important problem that the former camp inmates face. During the break, I talked to Mr. Peter, and I must say that I haven't seen a better report than the one that deal with key problems. These are reparations for victims of tortures. Camp inmates are a category that has not resolved their issue yet. There is no letter written on this. We worked on proposed law and we submitted this proposed law to the institutions of Bosnia and Herzegovina, and we expect it to be discussed by 10th December this year. I like three key issues that the IOM defined in their report, primarily establishing the number of the victims of torture. And second, information pertains to reparations of victims of torture in accordance with economical state in the country. And the third, memorialization of the place of their suffering. I would kindly like to ask you, on behalf of the Association of Camp Inmates of Bosnia and Herzegovina, which has 59 association and gathers 50,000 camp inmates, that in discussion with members of authority you should exert your influence and ask them, when we speak about the law on the rights of the victims of torture, and I already submitted this proposed law to Mr. Peter, and I hope that he will find time to translate it into his official language in order to be ready for the next meeting on next Friday with representatives of Council of Ministers. This is our last chance that this law on rights of victims of torture to be a unique law. I'm not referring to Bosniak victims only, Serb victims only, or Croat victims only. I refer to everyone as camp inmates in general. Please make any effort necessary. When we refer to the talks and dialogue with the authorities of Bosnia and Herzegovina to exert your influence that this law be passed, I would like to extend my thanks to those who worked on a report on reparations.
Thank you very much. Other comments? Perhaps? Yes, please. We're getting the microphone there. Yes. Perhaps this...
Good afternoon. Thank you for an excellent conference that is organized to take place today in Sarajevo. I would like to congratulate the 20th anniversary of your work, regardless of all negative or positive comments. My name is Branka. I'm the president of Association of Snaga Žene, Force of Women. For 20 years I've been working with victims. What I would like to say, considering that I'm a doctor, I'm no lawyer or anyone who should be a judge of anything, I maintain that difference between justice and fairness should be made. The fairness is the thing that our victims need. It is satisfactory of one part of reparations, more precisely rehabilitation of victims. Through proper rehabilitation, tension that we were witnesses of here today would be reduced. Rehabilitation and satisfaction of all their social, economical, health, psychological needs, including economic and material. It's one and the same thing. We can reach the situation where one person, when one man who has suffered a great trauma related to the wartime events, let alone problems of women who survived rapes, and how many institutions are needed to help those women. On everyday basis, I talk to these women, their husbands, their children, their grandchildren. We have one circle of extending this to generations. In the future, we will not be a healthy society unless we have a proper rehabilitation, remedy, and satisfaction of all those people who are true heroes when they suffered so much and survived. One more thing, which is very important, is children. Work with children. We must not forget this transgenerational transfer. If we are not working with victims today, in the future we will not have a good future. We have to work for our future today. because if we are not following this model, it is certain that we will not have a good future that all of us are striving to. Our lives are short. I don't understand why the war and why the conflict.
Thank
I
you.
think it
Thank
is
you very much.
insufficient.
Okay, we could have maybe one or two more comments. One over here and one over here. Okay, one over here.
Ja ću još jednom progovoriti.
Well, let me speak once again of women of Vukovar, women who were raped, women that have only been discussed in the last 2 years since this book was published. What women of Vukovar always emphasize and what they truly want is justice. Without justice, we remain in a situation that a memory of a nation only includes things that can cause bad relations between different nations in the future. One more thing, as the doctor said earlier, what is necessary is psychological assistance. For the first time this year, women who were raped in Croatia have organized therapy. I believe too much money was spent on different types of support to civil society while victims remained aside. Legal assistance is something that those women do not receive today. Something that we keep working on, that we keep insisting on, and we have been supported by UNDP and the Ministry of War Veterans, but I'm unclear what is with those resources. It's less than a new car that the government of Croatia keeps buying. So the law is obviously not going to be adopted this year. We hope for the next year, and we hope it will finally be the first law covering the segment of women that are raped and rights of those women. And this law is probably going to be useful to other countries as a starting point of some sort. I was shocked when I heard that the situation was the same in Bosnia and Herzegovina, but the fact is that constitutions of some countries have it forbidden for people who were terrorists or involved in any criminal activities of similar sort. They are forbidden to ever work in state institutions. People who actually participated in war crimes are supposed to represent new forces in democratic developments that are taking place in our countries. How can that happen? How is this possible? It's impossible that someone who was a warlord can become to a new democratic society of today. This is the problem that I've heard of in Bosnia and Herzegovina, but the situation is the same in Croatia. In Vukovar, for example, when women victims of rape go to the authorities, they see faces of men who were who were their torturers during the war times. It will be my pleasure to give you one of those books.
Two of you
in
wanted,
English.
let's go back to our victim associations. Two of you wanted to speak. Let's give the word to both of you, please.
Šta?
Telefon mi je negdje ispod. Me, once again, I promise I will not talk for long this time. I just wanted to share with you this recommendation that I have, recommendation for the future. Since the first time I spoke of the past. All the verdicts of the Hague Tribunal or domestic courts in the future in Bosnia and Herzegovina and the region should include legal sanctions, aside from the legal verdicts. I did not talk of sanctions earlier, because if that was the case until now, if the verdicts of the Hague Tribunal included this legal sanction, today we would not be talking about reparations, suffering of the victims and so on. Because those who organized crimes, and this is now fact-based. We have two cases, Krstić and Tolimir. We know what those verdicts contain. So to go back to those who organized, who orchestrated the crimes and genocide. They also thought of the mechanisms to defend themselves later on. So today, at the Office of the Prosecutor of Bosnia and Herzegovina, Court of Bosnia and Herzegovina, we have people, we have employees who participated in those crimes during the war. Today, the situation would have been much different, I am sure, if the verdict included this legal sanction. So, for example, it would say NN committed a crime, killed 1,000 people, and the institution on whose behalf he did those killings is obliged to pay reparations to the victims. So if that was a part of the verdict, the perpetrators would not be perceived as heroes where they live. We have a situation like that in Pale, right here in Pale. They would be thought of as criminals. So it's my recommendation. I would really like it if the Hague Tribunal could use the mechanisms it has on its disposal to exert pressure on the authorities of Bosnia and Herzegovina to simply, if nothing else, start implementing the law on missing persons. To simply just implement it. I think that would solve so many things regarding reparations.
Thank you very much.
And
Thank you.
so many other things.
Very useful. Yes, your colleague.
Fikret Grabovica, President of Associations of Parents of Murdered Children of Sarajevo under siege. Several sentences only, because I had an opportunity to speak earlier. I would say a few things about Sarajevo, because no one's mentioned Sarajevo until now. Sarajevo was a big concentration camp for almost 15,000 days, and even longer, because in Sarajevo, on a daily basis, I believe Mr. Meron was in concentration camp himself when he was 12 years old, so he understands how this is back in the Nazi Germany. So you can imagine in Sarajevo, 1400 days, during the 1400 days, 1,600 children were killed, 11.5 thousand civilian victims in that period of time. So you can imagine how enormous was this crime. And for all this, only 2 perpetrators were on a trial. That sounds simply impossible when someone says those figures. In the 20 years of the Hague Tribunal and judiciary of Bosnia and Herzegovina, domestic courts in Bosnia and Herzegovina, only 2 perpetrators. And I have to say that I'm really, really disappointed by this fact. As far as reparations go, I think they are very important for several reasons. I will state 2 practical reasons only that are of concern to the population that I represent. Since many parents who lost their children had new children in the meantime when they were older, and some of those parents lost even 2 children during the war, and they also have new children in their families. They all had children when they were older, and now they're trying to educate those children. Their economic situation is not great, and education is very expensive in Bosnia and Herzegovina. So many of those parents are not able to provide appropriate education for their children. Aside from that, many parents, we can even say all the parents who lost their children during the war in Sarajevo, are ill on different accounts. So they need medication, they need psychotherapy, but all that costs a lot and they cannot afford it. So they are in a very difficult situation. Many of those people are in a really difficult situation. So for that reason, reparation is something that we really need here.
Thank you. Thank you very much for those comments. I think I would like to come back to our panel and And my intention in opening up the session this way was to really to inform our discussion based on your reflections, because I think the experts, the people who deal with these issues on a daily basis are the people sitting in this room in various functions, particularly the victims themselves who are affected directly, but also those who are working with victims, as we heard as well. Several issues were raised. If I can just try to summarize the issue of material, non-material forms of compensation or reparation. It's not, many people would say it's not about the money, it's about education for children, it's about health services, it's about, as we heard, providing conditions so that this can be a healthy society. Looking at the remarks on this side about the second generation, the transgenerational effects of violence and trauma. So it's actually looking towards the future, it's providing conditions for a healthy future. The issue of lustration was mentioned, the fact that those who are responsible for crimes are still in positions of power and authority in this country and elsewhere in the region. The issue was also mentioned, particularly with regard to the issue of benefits for camp people who are interned in camps, and also rape victims. Very different issues. Torture victims, rape victims have to be dealt with it in a different way. These are also gender issues at stake here. So how do you develop a reparations policy which is gender sensitive and victim centered at the same time? I think these were the most of the comments. Of course, what belongs to this as well is the legal framework. How do you develop a legal framework which will serve these different needs? And is there a regional approach to this, or has to be done on national level? Because each country has its own national legal framework. So these are some of the questions I think were raised here in the audience. I'd like to come back to our panel and begin a reflection, a kind of response to those issues raised by you. And I would first like to do so, again, we would like to feature the report. One of our members of the audience mentioned specifically the IOM report. I'd like to call on our colleague from the ICTY, from the cabinet, Deputy Chef de Cabinet, Alexandra Zevros, to tell us a little bit the background, why it was that the ICTY took the step of mandating the International Organization of Migration to do a study on reparations.
Thank you very much, Jonathan. And on behalf of myself and President Meron and the entire ICTY, I'd like to thank you for all your assistance with this conference and for chairing this panel. I also want to thank Peter and the IOM for a really fantastic report, which will form the basis of the discussion today. And indeed, to thank all of you who have braved it out till this, the last panel of the conference, and who have already provided such interesting and stimulating comments on which we can base our discussion. To go immediately into the background issue, as President Meron noted in his keynote address today, the mandate of the ICTY was very clear and very limited from the start: to try particular individuals accused of crimes within the tribunal's jurisdiction and to establish whether they were proved beyond a reasonable doubt to have committed those crimes. The ICTY, through its operations, and indeed other tribunals as they began to operate, quickly understood that such trials were not sufficient to address all the trauma that exists, all the problems which come in post-conflict situations and which are caused by these crimes. And multiple ICTY presidents, including past President Judge Patrick Robinson and Judge Theodore Meron, approached multiple interlocutors, including the Security Council and others, specifically on the issue of reparations, asking that the international community supplement the work of the ICTY and expand into that field. I'm not going to beat about the bush. Very honestly, when the presidents approached the international community on reparations, the reaction was very negative. The ICTY was told to focus on its mandate. Anytime the issue of cash or material goods was approached, donors were often not very happy at all. And in the face of this particular response, the tribunal decided to task or ask for the assistance of the IOM to explore potential possibilities for moving forward on the reparations issue. Because the tribunal saw reparations and broader issues related to it as so important, we thought we needed a fresh look, since our activities and efforts were, as is clear to everyone, not successful up to that point. And we got this very useful report, which, amongst other things, provides a basis for discussion, which is why we included this issue in our panel on the 20th anniversary. And I'll also note that the report had a very interesting perspective, which was that the ICTY may indeed not be the right institution to move this forward. And I welcome some discussion about which institutions are the correct ones to address this issue of reparations and make sure it works. And finally, I just wanted to say that I was so encouraged by Mr. Tahirovich's comments about how reparations are beyond broadly the material issues and encompass a whole range of ones. I think that's a very sort of material and useful contribution which we should keep in mind as we move forward.
Thank you, Alexandros, for your words about the explanation why it is that we're having this panel at the ICTY conference. Let's just then move on directly to Peter van der Auweraert. He was mandated, IOM was mandated to produce a report on reparations, large-scale reparations, from a comprehensive perspective. So, Peter, could you fill us in on some of the details, some of the main points of the report that you produced?
Let me, thank you very much, Jonathan. Let me first start with, well, first of all, thanking the ICTY, the former president, and some of his former collaborators who are here today and now work for other organizations, and the current president of the court for asking IOM to do this work. And thank you very much, and I think it's very appropriate that in a conference on the 20 years legacy, we talk about reparations, because, and that is not the fault of the ICTY, but the 20 years legacy is also a legacy where the international community has invested all its resources in punitive justice. And we've heard a lot of critiques today and things that could have done better, but the fact remains that there's been an enormous investment, material, politically, technically, in punitive justice. If we compare the amount of investment that the international community has done on restorative justice, on reparations for victims, we see that that is very small compared to the efforts that have done or have gone into punitive justice. This is not unique to Bosnia. An example that I like to use, and where IOM has been involved in assisting the government with providing reparations in Sierra Leone in Africa, when we look at the trial of Taylor, who was one of the warlords, and the amounts may not be entirely correct, but the cost of the trial was about $250 million to have one person convicted. At the same time, the international community, and together with some other UN organizations, UN Women, IOM, the UN Peacebuilding Fund, we were struggling to get together $6 million to provide reparations to thousands of victims. So this issue of where does the international community put its money, is it $250 million on the one hand, $7 million on the other hand? That is not an argument to say that the ICTY or the Sierra Leone court should have received less resources. That's clearly not the argument. But the argument is that the victim side also needs this type of investment and this type of resources. The second thing, thank you note, that I wanted to say was to the associations and the people here in the room who very willingly gave their time to talk to us about what they thought about reparations. I can imagine 20 years after the conflict ended, when there's another international person coming to ask you, so what exactly is it now that you want, that you may be tempted to say, please, I don't want to spend my time anymore on discussing the same issue over and over again. So I very much appreciate that people took their time, and the people in the room who we spoke to, they're mentioned in the report at the end of the report, and thank you very much. We would not have been able to do the report without your input. Let me be very blunt in terms of, and I'm not going to go into the details of the report. The report is out there. I've presented it already here in Sarajevo, where a number of you were present also. I think as an international community, but also as national governments, we have to reflect on how can it be that after all the money that has been invested in Bosnia-Herzegovina, we still have situations where victims of sexual violence, people who were tortured in camps, have not even been recognized, do not have access. The parents, as were explained in Sarajevo, do not have access to psychosocial care, health care. How can that be? And that was for me maybe the most shocking finding initially of, despite all the efforts, despite all the work that civil society organizations are doing, there are really people out there who have not had access to the most basic of health services or psychosocial services. So where is all the money gone? Because the international community has put an enormous amount of money in the Balkans. And yes, I understand reparations is politically sensitive and it has all sorts of issues, but frankly, that is something that we need to talk about. Why is it that there are victims out there who not recognized and they don't have access to services? And what you will say when you talk to international community, donor states, governments, they will say, well, reparations is too expensive. Well, it's not even about additional money. It's the question of how do you are spending resources that are there today. Reparations, providing people with access to basic services, is not very expensive, and there is money available to spend, and more could have been done with the money that is out there. So I think that is one of the key findings, I think, or the key issues that the report hopefully raises, is this issue of, it's really not that complicated to do, frankly. It's not rocket science to make sure that people have access to the services that they need. And I think more could have been done with the resources that are out there. In terms of what the report tried to do, and I was very encouraged by the kind words that were spoken earlier, is not to say, oh, here is a model of reparations and please go ahead and implement what we are suggesting, but rather to say, to help the discussion and say, let us break down this issue of reparations into a number of issues that we need to discuss together. Who are the victims? What type of benefits do victims need? I was very encouraged, and it's very important, this message that you are giving also to the governments. For the victims, it's not about the money only. Material reparations are important, but there is also the symbolic element of recognition. And recognition does not cost millions of dollars. That is something that can be done. It's also about access to basic services. So I think we try to maybe break down these reparations as a concept into hopefully useful topics that we can discuss and that politicians need to discuss to move from, yes, everyone has the right to reparations, to how do we actually set up a program. I wanted to highlight maybe some of the points that in the different presentations have raised some discussion. And I think first there is the issue which we tackle in the report, and Jonathan mentioned it. Should efforts be done at the national level or at the regional level? In the report, based upon the consultations that we've had, based upon the considerations that we list, there is a suggestion that the regional approach may be more appropriate. One important element for me there, and that is not me, but that is what I learned from people, is this element of recognition. Is it really possible for victims to be recognized if there isn't a regional effort to recognize? Because people don't need to be recognized by their own community. Everyone is recognizing their own victims. The question is, how do you get to a point where everyone together recognizes that in all communities there have been victims? And I think one of the great things of the law that is being hopefully discussed on the 15th of December in the Parliament is exactly that it looks at victims of tortures. Not Bosnian victims, not Croatian victims, not Serbian victims, but people who have been subject to torture. And how do you get that element of this applies to all victims, the recognition, if you don't do it at the regional effort? It doesn't mean that national efforts shouldn't go forward, but hopefully, eventually, at least in the report, we suggest that the regional effort might be the best approach. We also discussed the issue, and maybe that is already a little bit too technical, and so I'd be happy to discuss this on a separate occasion. But one of the questions that is often raised is, we talk about reparations. Are they related to the violations, or are they related to the damage that people individually suffered because of the violations? In the report, based upon international experience in other countries, we suggest that given the thousands and thousands of victims that are there in the former Yugoslavia, it will almost be impossible, I think, for a reparations program that tries to be comprehensive to look at each individual and identify exactly what that person lost. You have 7 people who are victims of torture. Is it really possible in each case to identify this person, that has been the effect, that person, that has been the effect. Is that feasible? Or is it better to think about reparations that are based upon violations? Everyone who's gone through torture has a right to a remedy, and then link it not to the specific damage but to the violation. So that's one of the conceptual issues that we discuss in the report. Maybe as a final point, because I do not want to take up too much, or two final points, I don't want to take up too much time, is, and I think that has, it's an important message to give to the governments also. First of all, I think there is a consensus amongst people who work in this, on these issues and people in the room here that a comprehensive reparations effort is required. And that it's important to pursue different initiatives. And I think, for example, and we discussed this earlier, I think the law for torture victims is important and the parliament should adopt it. It doesn't mean that that would be the end. That would be the first step, and then still other victims also need to receive similar type of treatment in a way. So a comprehensive effort, I think, is critical. And I think it is important to highlight to the governments, and that is why I think, for example, the work that a lot of you have been doing on strategic litigation, when governments say, well, we can't afford to do reparations, comprehensive reparations because it's too expensive, I think we have to say, well, it's not a matter of are you going to spend resources. If you are not taking proactive action and establish a comprehensive reparations program, you will have courts like the European Court on Human Rights that will tell you to pay money. And if you're a politician, what is the best thing to do? Is it best to be proactive and actually have a law and take credit for setting up a program? Or is it better to pay out compensation when the court in Strasbourg forces you to do so? And I think it's very important as a message. Reparations is not an optional thing. It needs to be done. Let me end with this, with the next steps, because we have been going around to present the reports. We have been in Kosovo. We have been in Serbia. We have done a presentation here in Sarajevo. I will do a presentation to the European Commission in January. We're going to Banja Luka on Friday to present the report to the Council of Ministers there. And we're also trying to organize a presentation of the report in Croatia. The idea is not to say, oh, look at this fantastic report. The question is to see what are now the next steps. How can we now move from all these discussions that we've had, and you have had much longer than I had, about the issue of reparations to an actual reparations program for all the victims of international crimes committed during the Yugoslav wars. One important thing, and I can make this, we've discussed this before, and I can make the commitment here. IOM as an organization, we are committed to support whatever process nationally, regionally is there. If our technical assistance is required, is useful, we are happy to support. But we as an organization, we cannot support the reparations. We don't have a political mandate to work with governments at the political level to move forward on this issue of reparations. So it's a plea to other organizations in the room whether we can partner up with an organization like OSCE, like the European Union, like the European Commission, who can carry this file at the regional level politically, because that is not something that IOM can do. I can, as a technician, provide input, technical assistance, support. We're working together here in Bosnia-Herzegovina with UNDP in the context of the transitional justice strategy, but we cannot carry this file alone politically. So we are desperately looking for partners to work on this. Thank you very much. I hope I haven't taken up too much of the time of the room, and thank you again for all the people that were available to be consulted about the report. Thank you.
Well, thank you, Peter, for not only your presentation here, but for all the work that you and your colleagues did in producing this report. Again, we think it's an excellent basis for a discussion, and I think we're very encouraged by the steps that you're taking. And certainly the issues that you've raised, we'd like to deepen in our panel discussion in a couple of minutes. Speaking about next steps, however, I did mention that we had a working session yesterday with some of the panelists here and some additional experts to prepare this panel presentation. And what are the issues that, from our perspective, which are important to see, and how do they mesh, how do they fit with the issues that you're seeing? And this is why we began with your perspective. So I'd like to ask now Ivona Tsarkovska, to come up here and present. She's the rapporteur of our working session. She can present some of the findings and results of our discussion yesterday.
Thank you,
Ivona.
Mr. Sisson. The working meeting yesterday gathered a wider group of resource persons and experts on reparations, and our distinguished panelists present here today were part of this group. This verbal report will be a short outline of their contributions and the discussions at the workshops rather than detailed meeting minutes. We began the session with a round of introductions of the members and a brief update in regards to their work related to reparations in particular. Then we proceeded with the introduction of the genesis of the IOM report on reparations of wartime victims in the former Yugoslavia and the way forward now that we have this product
Please, a bit
in our
slower,
hands.
a bit slower, for
Okay.
our translators.
Yes. Peter van der Auweraert has provided an update on the presentation of the report in terms of what was done after the report was published, with insight where and to whom it was presented, highlighting that the aim of these events was not to publicize the report, but rather to discuss the report and suggested steps forward. This process, as informed by Mr. Auweraert, will continue in the future as well. Following the presentation, there was a discussion on the report, which focused on the findings and recommendation of the same, but also going beyond the report to include other issues closely related to reparations. Some of the key issues that the working meeting discussed were: reparations have been identified as one of the most neglected aspects of the transitional justice in the region, leaving many victims that suffer deeply without effective remedy and help. The necessity to adjust language and approaches when discussing reparations with different target audience, such as the international community, national politicians, victims, and general public, is important in order to ensure common understanding of the subject matter, which today seems to still be lacking. We also discussed the dichotomy between the regional and national approaches, and the consensus in our group was that both approaches are equally important and they shouldn't be looked exclusively, but should go hand in hand and mutually reinforce and complement each other. Ongoing regional initiatives such as the Sarajevo process, the RECOM initiative, and their significance in terms of using lessons learned in the process of establishing comprehensive reparations effort were considered. In the same line, positive national examples can be used to build regional efforts on, to the extent which is possible. In terms of political initiative, the group agreed that a clear demonstration of commitment from the political actors, both at national and regional level, is needed to move forward in the area of reparations, with clear acknowledgement, though, that this process can be at times hampered by other conflicting and diverse priorities of different governments. The group also discussed the need to balance expectations and preferences of victims and other stakeholders in setting up a comprehensive reparations efforts with the limitation imposed by feasibility, resources, and practical considerations of such efforts. The discussion also included the needs to address the issue of mobility of the victims, as many victims have suffered human rights violation on territory of states where they used to live, but they are not longer there. In terms of next steps, the following items, which I will shortly present, are not something that the group has agreed upon because it was not a decision-making forum, but rather some specific suggestions that were put for consideration and we would like to put for your consideration as well. These next steps could include actions to identify an international and or regional organization that could take the issue of reparations forward, organization of a regional political meeting at high level that would build on the existing discussion and momentum for reparations, reinforcing discussions on national and regional level through organization of targeted workshops involving variety of stakeholders, victims association, other civil society representatives, international organization, government organizations. The third, actually fourth point, which was brought as next step suggestion, was discussion on identifying different funding modalities. One issue that was discussed in the group was the seizure of ill-gained wartime assets as one partial source of funding, and building up a picture of the cost associated with the reparations effort. The main conclusion of the working meeting was that there is a clear need to organize and hold further national and regional dialogue sessions on reparations, including both civil society actors with a key role for victims' representatives and government and political parties. I would stop here and leave more floor to our distinguished panelists. Thank you. Hvala.
Well, thank you very much for Ivana. Thank you for the work in typing up those notes. Just a moment. Yes, do you have a comment? Excuse me, sir. Do you have a comment on this thing? We're coming back to a discussion in a moment. If we could just continue a little bit to deepen some of these issues, we will be coming back to the audience. So one of the issues that was raised yesterday was the issue of common understanding. What do we mean when we're talking about reparations? We have with us a legal expert for the organization Redress, which is an organization specialized on the issue of remedies and reparations for victims. And I'd like to ask you, Jürgen Schür, could you tell us the international norms and standards with regard to reparations? What is the definition of reparations? And in this regard also, perhaps a word or two about who is a victim? Who is the potential beneficiary of a reparations program?
Thank you. Thank you, Jonathan. And thank you also to the ICTY for inviting us to participate in this important meeting. I think the fact that we are having a discussion on reparation is also an indication that reparation is actually part of the legacy of the tribunal, because without the tribunal and its work over the past 20 years, we probably wouldn't be as far as we already are in regards to the law on reparation. If we look at the developments on the right to reparation under international law since the establishment of the tribunal, there were quite significant developments, including in particular the UN basic principles that were mentioned before by Jonathan on the right to reparation, and that very clearly provide and outline what reparation actually is under international law. And it very clearly spells out that reparation has two aspects: a procedural aspect that where states must provide victims of human rights violations and of violations of international humanitarian law with the possibility to obtain reparation. So states are obliged to put in place effective remedies, a route to obtain reparation. And that can be a legal route, as in form of, for example, court procedures. But it could also, and that is reflected in the IOM's report, be by way of a reparations program, which is not judicial but more administrative in nature. And that brings me to the substantive aspects of reparation. And we've heard it throughout today, and especially in this session. Obviously, reparation, and that must be emphasized over and over again, because there is a misperception of what reparation actually is, especially among policymakers and decision makers in government. Reparation is not only about compensation. Compensation, as we heard, is a crucial factor that helps victims to address some of the economical consequences that they face as a result of the violations, but it's not only that. It's also restitution of damaged property. It's rehabilitation, we heard several times just now, particularly important in regards to torture and sexual violence, so as to address the medical and psychological consequences. Satisfactions as a measure of reparation was also mentioned. It is important to recognize that the investigation and prosecution of perpetrators is a form of reparation, is a form of satisfaction, which must form part of the right to reparation. We heard today several times how important this aspect is, especially in regards to enforced disappearances, knowing what happened to family members. And then last but not least, of course, guarantees of non-repetition, so as to avoid violations in the future, which can include changes in the legislation, law reform, but also, for example, training of army or police authorities. So this is a very, very brief overview of the different forms of reparation. Now to the definition of victims under international law even more briefly, because it's very well covered in IOM's report, which you have all read. It's important to define victims, first of all, because as Peter was saying, in order to give recognition as a victim, which can be a form of reparation in itself, but also because the status as a victim, of course, gives rise to certain rights, including the right to reparation. The basic principles very clearly spell out that victims can be individuals, but, and we haven't discussed that so much to date, also collective victims, so or communities and groups who have suffered collective harm as a result, for example, of genocide or massacres committed in certain villages or other locations. Victims can also include family members, of course, and there it would be important to identify to what degree relatives are included in any reparation efforts. It is very important also in this context that victims are victims irrespective of whether the perpetrator, one second, I'm almost done, whether the perpetrator of the violation is identified. So a prosecution or an accountability and a conviction process is not necessary for a victim to enjoy victim's status. And I'll finish here and leave more time for the rest of the panelists and you.
Thank you very much for this brief explanation about the legal norms and standards regarding reparations, and also the who is a victim, the definition of victimhood under according to international law. Is there a question right now from the floor? Any comment from the floor? If it can be brief, just a brief comment.
Interpret. Microphone. Microphone, please. I would like to underline one or two things. The previous president Robinson always talked before the Council of Security that a fund for victims in Bosnia and Herzegovina is required. I know that the new president who is with us here keep talking about this, and I hope that he is going to continue underlining this in his future reports. The law on missing persons of Bosnia and Herzegovina, if applied, it had already been adopted, but our government since Lady Europe made it to have 3 presidents and several governments. They cannot find a mutual agreement. They could not have agreed where the seat of the fund would be, either in Federation or the Republika Srpska. So this law underwent through all procedure. It was published and adopted by the Parliament and House of Peoples, and it is now kept in a drawer. But this law includes everything: fund for the victims, marking the memorials, funeral, family entitled to attend the funeral, and all sorts of things, because the families took part and contributed to the passage of this law. The best law in the world and the only law that was drafted in Bosnia and Herzegovina. I would like to say something to you. The definition of victim has still not been drafted. In my view, the victim was not a member of a paramilitary unit or any military, either Bosnia-Herzegovina military, HVO, or army of the Republika Srpska. He is a soldier of the army, and he should claim damages from the army who sent him. In my view, a victim is a person who did not took to arms, who was brought without any weapons from their houses and basements. As Association of Mothers of Srebrenica and Žepa, we were under the protection in Srebrenica, and crime and genocide still took place. We sued the UN and the government of the Netherlands and the Ministry of Defense. We exhausted all the courts, and then we sent our appeal against judgment that he cannot be held responsible before the European Court for Human Rights, and we received their response that the UN enjoys protection and cannot be involved in discussions. My question to you is, can somebody commit a crime without being held responsible? And I received one message from a lawyer where a trial was scheduled in Netherlands on the 23rd of March, where the government of the Netherlands Ministry of Defense would stand trial for the things that they are responsible for with respect to the Srebrenica events. I'm asking you, who can help us as victims, for us to be able to have a fund and to be able to attend this trial? Of course, we should go there and to attend the trial. Who can give us support? I believe that the biggest support to us would be that you, who deal with human rights issues and justice issues, to give us support in any way when these things are to take place. Because Srebrenica still has resolution 819. Thank you.
I will take one more comment, and I want to come back to our panel. From this gentleman here, he raised his hand. Thank you. This gentleman here, please.
I take the floor for the first time. I come from Brčko. I'm the representative of the killed Bosniaks in Brčko district. I will not take up a lot of your time. All things have already been said. But I have one question for Mr. Alexander, because he said benefits for the raped women and camp inmates. Mr. Peters said reparations for violence and damage that was incurred to people. And the last speaker mentioned the compensation, restoration of property for those who were tortured and sexually abused. I support everything, but my question is, what about the families of the killed ones? Based on your speeches, I did not recognize them anywhere. Since I represent the family of the killed, I believe that they are entitled to reparations. What is your conclusion? I didn't notice this category mentioned. Since I took the floor, I would like to inform you that 20% in Brčko district, if we initiate civil proceedings, 20% is taken, margin or profit is taken for their services. If the reparations are 15,000 km for killed children. In that regard, can you help us in any way with respect to legal advices? And this would be helpful. It is a lot of money if somebody takes 3,000 out of 15,000, and then they also charge their services from the Republic of Srpska, so they take up to 40%. I believe that it is too much. That's all. Thank you.
Thank you very much. I'd like to go back to the panel now, and I have several panelists here who haven't had a chance to speak. We'll come back, please. Yeah. So I would like to, again, speaking, these are very specific cases. They are in need of being addressed. On the other hand, what we heard from our colleague about, according to international norms and standards, what we are talking about are rights of victims on the one hand, and communities, and the obligations of the state on the other hand. And we know that the state has been remiss in its obligation to enact laws and to pay compensation. And this is not only in this country, in Bosnia, but across the region. There are laws for missing persons, which have been partially implemented, but there are other victim groups, as we heard this afternoon, which have no legal basis whatsoever for their claims. So there's been a deference to certain groups of victims over against other groups of victims. So this is about, but on the panel we have several members who are engaged in this issue. We have members here from civil society who have been the most active on this issue, and we have other members of the international community, representing international community here. I would like now to ask Sandra Orlovic to give us a reflection on her perspective. You've been very much engaged in Serbia and your organization in filing claims for victims, so litigation, but you've also been engaged in the civil society initiative, RACOM, which is a fact-finding initiative to establish a fact-finding commission. And here I would like to hear a little bit more from you, the linkage between fact-finding and reparation. Do you think RACOM could be a catalyst for a comprehensive reparations program in the region?
Thank you. Hello to everyone. Good evening to everyone. Let me first say something about the court proceedings and the claims that the Fund for Humanitarian Rights has initiated on behalf of the victims. So let me try to explain, let's all try to analyze why such claims. Not only in case of Serbia, but also in case of certain claims coming from certain associations of victims from Bosnia and Herzegovina and so on. We all know that in each country there are measures called reparations. I am among those who believe that such measures in the countries of former Yugoslavia cannot even be called reparations, because in their essence, in their nature, those measures are social measures, in my opinion, measures provided to victims and their families for the sole purpose of the countries or employers seeing them as persons who cannot make their own living anymore. So in all those laws, in every single country of former Yugoslavia, victims of rape or torture, for example, have to prove that they live with the injuries inflicted to them, injuries within the range of 50 to 60%, I believe. I think that is humiliating. I think every victim has to receive certain compensation or state support for the fact that this person was a victim of a human rights violation, not because the person is not able to work and make a living for their family any longer. Aside from that, aside from all the state measures of support, neither of the laws defining those measures does not feature half a sentence on the symbolic recognition of suffering, symbolic recognition of responsibility for what happened to the victims. In the Federation of Bosnia and Herzegovina, for example, you have a situation where the civilian victims of war, their rights actually are defined in the law on social protection of families with children. So that's how it's regulated in the Federation of Bosnia and Herzegovina. In my opinion, that has nothing to do with the symbolic aspect that reparations have to bring. That is why numerous victims from Bosnia and Herzegovina, Croatia, Montenegro decided to sue the countries or the entities they find responsible for what happened to them. Despite the fact that those families or those victims have a certain type of support from their state, they still want the formal recognition by those who perpetrated the crimes. So I believe that is the answer to your question, Mr. Ziach, if I remember your name well. You were saying that those who perpetrated the crime should pay for the reparation, and those claims are an expression, let me use that term, of an expression to recognize the suffering, for the suffering to be recognized by those who caused the suffering in the first place. In my opinion, a regional fund directing the funds for compensation, for reparations, would consist of money paid by all the countries, all the participating countries, could create this impression that what happened, the sufferings that were caused to the victims, there is someone responsible, and that those responsible are paying. I am not against the participation of international community in such fund, of course. On the other hand, this regional approach, which was one of the conclusions in this excellent report of the IOM, the regional approach provides yet another good, positive aspect regarding the reparations. Before we start talking about the reparations, we have to establish who the victims are. Today, in the region of former Yugoslavia, we have several registries of human losses put together and still being put together by certain NGOs. However, that is not enough. There has to be a register of victims of torture, register of victims of sexual violence, former camp inmates, individual registers, for the simple reason that we have to avoid the situation that we have now, which is that in different countries, victims of the same crime are treated differently. In Serbia, for example, 2 or 3 months ago, the government of Serbia adopted a decision to discontinue the status of the civilian victims of war to women who are the former camp inmates in Bosnia and Herzegovina, because they were not citizens of the Republic of Serbia at that time. So we have different approach to crimes based on the place of residence. Victims have different treatment and they are not recognized in the same way in different countries. I believe that's enough from me for now.
We know you have much more to say because your organization is very active. But I would like, I am watching the time. We will slowly have to come to a conclusion. But I wanted to ask our other panelists very specific questions and ask them to be focused and brief in their responses. We have a representative of the UNHCR among us, Mr. Andrew Main, and I'd like to ask you to what extent, I mean, it's mentioned in the report, the IOM report, the Sarajevo process and the regional housing program. To what extent could this be a model for a reparations program? It is, in respect, a reparations program. The right to return is an element of the right of reparation, refugee return, IDPs. So you're engaged in developing this or in implementing this regional housing program. To what extent do you see, could it be a model for a reparations program as described in the IOM report? And to what extent is there a linkage? Could there be some kind of collaboration, cooperation between these two programs?
Thank you very much. Let me say very briefly that the Sarajevo process is a result of many years' work, and it represents a lot of engagement, a lot of patience by many actors. And so here, in the case of the reparations process, participants in the meeting have described how other processes have taken place, have perhaps also taken many years and may have stalled and not come through. What's very important here is that the ICTY has again raised the profile of the issue, has commissioned a good report with the IOM, which is taking a very tactical approach to the issue of how this process can actually be brought forward. And I think that's a key question in this conference, in the concluding session of this conference, how can this process actually be brought forward? The lessons learned, if you like, from the Sarajevo process would be that, as was mentioned earlier, the organization needs to be identified that can drive the process forward and can commit to the process the necessary patience and the facilitation over several years to see the process through. This is not an easy process. And so I think it's extremely positive that the ICTY, which represents in the region all of the efforts to provide even-handed administration of justice, is already behind this process. I would ask the ICTY to continue carrying the process until any better organization is found. I think that the other element which was important in the regional housing program, the Sarajevo process, and so on, is that the governments already had some, while it took a lot to achieve this, but they had some interest in talking to each other on the issue. And so if that exists in the region, if there are clear signs that that exists, then that should be built upon. But if that is the difficult part, then a different tactic would need to be found with regard to the reparations process. And the role of civil society could be extremely important in that case. So a combination of a lead facilitating organization, even just carrying the issue, such as the ICTY, and the engagement of the civil society organizations who do manage to talk to each other in the region, to identify to define the groups of victims, to identify the extent of the needs, the kinds of reparations that would be required, the kinds of measures that would be appropriate, to negotiate that within the region and to establish a proposal could be a helpful way forward in this process, carried by a supportive organization. And then the results of that could be taken further, taken up, discussed with governments and so on, and the organization that would carry the process forward through subsequent stages could have been identified during that period. I think that this is the kind of, for us, having worked through the Sarajevo process, which is a very imperfect process, but did succeed in bringing 4 governments of the region together to sign up to common objectives. And those governments are now able to sit down and resolve the problems, possibly even the wider problems of resolving the remaining problems of displacement. There's great potential there, not only for the housing element, which is currently the main focus of the project, but the ability to discuss the issue, having set out the terms, the ability to take that forward in a way that's satisfactory to all of the parties is very important. So we have to try to bring this process to the same stage by one means or another. Thank you.
For that, thank you for that, those remarks. Just to stay for a moment, we're coming back, Let me give my chance. I would like to add, we have a representative of the European Union with us, a legal counsel, and I'd like to stay on the political level for a moment. And as you know, one of the important issues with regard to the European access was the issue of conditionality, cooperation with the tribunal. And in our approach, and as we've heard from with regard to the issue of the right to reparations, the transitional justice, the right to justice is one pillar of transitional justice. The other pillars being the right to truth or the right to know, the right to reparation and guarantees of non-recurrence. My question to our EU colleague would be then, to what extent is this issue of conditionality also, would it be relevant for the right to reparation? Is the EU looking at the performance of the governments in this region in fulfilling their obligations with regard to the right to reparation, just as they were looking and are looking at the issue of the right to justice? Please.
Thank you. Yeah, let me say a few words about that. The criteria that we apply for accession into the European Union are by and large the same as they're expressed in the so-called Copenhagen criteria. Not because I'm from Denmark, but that's where the criteria were set back when. These criteria are the same for each country that wants to access the European Union, but when that's set, we do when we assess countries that want to approach the Union, as this country here does. We treat each country as an individual case, and one can't necessarily take one country and say it was done like this in Croatia, it will be done like that in Serbia, and therefore it will have to be done in such and such a way in Bosnia and Herzegovina. So same criteria, yes, but countries treated on their individual merits, so to speak. Historically, of course, the Union has taken an interest in this part of the world and in this country for a long time, stemming all the way back from the war and the period leading up to now. And we've had a close cooperation in the field of rule of law, in the dispense of justice. At the moment, we are our main vehicle in this country to look deeper into the justice issues is the so-called structured dialogue on the judiciary, where we have basically done what we define as an early opening of these chapters in the accession process that any country will have to go through, even though this country is not yet a formal candidate country for the Union.
Thank you. Yes, well, you've mentioned Bosnia-Herzegovina. Let me come now to my colleague Thomas Osario, working at UNDP. UNDP has been assisting the government in developing a strategy or a particular approach to transitional justice, again, from a holistic perspective, the right to truth and the right to reparations and guarantees of non-recurrence. Could you give us a little bit of update on where you are in that strategy?
Thank you, Jonathan. Thank you, ICTY. Let me just start by saying that this is yet one more 20th anniversary. It was 20 years ago that the United Nations provided irrefutable evidence that rape of women, girls, and men was widespread and systematic throughout the countries of the former Yugoslavia. The Commission of Experts, known as the Basiuni Commission, established these facts, and many of the groups that we spoke with then in 1993, I still speak with today. So we are looking to redress those wrongs, and reparations is about the redress of wrongs. But where does it fit? I think that it's easy to say, well, we will be approaching the government. It's not only the government, it's civil society, but it's all of you. We're looking for the recognition of wrongs, the acceptance that wrongs were done, and that's our starting point. The other issues now at this point are technical. We have a number of excellent platforms. We have worked with the government now for 4 years on a transitional justice strategy that has been controversial, but it has legs. It has the elements that are required to address the wrongs and to provide the tools to the government that, if accepted, could provide redress. Truth-telling, memorialization, recognition. I think that Jonathan started with the rights. We are looking at the rights. We're not talking about gifts from the government. We're not talking about gifts from you and civil society and supportive elements. We're talking about your rights. The right to know what happened to your loved ones, where they are, what was their fate. The right to reparations, which is now being addressed in this panel today, which is extremely important because the report that was issued by IOM demystifies reparations. It makes reparations understandable. It talks about the issues that you've heard in the panel, but most importantly, the issues that you have all been talking about now for a number of years. It's not about money. It's about a host of, money is a part of this. Redress, trying to right wrongs, trying to repair, because reparations is about repairing. It doesn't translate well. We were looking for a word in Bosnian, Serbian, and Croatian. Popraviti somehow doesn't work. In English it sounds a lot better, but it is about repairing lives. It's about repairing lives so that you can move on, or dealing with the past. So let me just say that we have a strategy. We are working with your government, UNDP, other UN agencies. We are looking to combat sexual violence from your violent past, but it will take your engagement, your understanding, your recognition of these efforts, and to address these issues as not only something that needs to be given to you, but your rights. You need to ask for those rights. Where we are now, we have the draft strategy. The draft strategy has now been recognized by the Council of Ministers. The Council of Ministers have deposited the strategy into parliamentary process. The Parliament will do its work in terms of identifying gaps, legislation. We hope that that will be a supportive element to the draft legislation which is before Parliament now on dealing with torture. But there are many other gaps in legislation that will allow the various levels of administration to work with you, to work with those service providers. I see many of our friends and colleagues here that provide services. These are important elements. The reparations is a part of that, together with a holistic package of transitional justice, if you will, or I think that it would be almost more appropriate to talk about dealing with the past. Transitional justice is somehow automatically linked with justice, but as you've heard and as many of you know, it's not only those judicial elements. So I'm actually asking for your help. This is a crucial time. This is a 20-year anniversary. It has been 20 years. I think, you know, I've known many of you for almost that long, and so this is, I mean, there's no better time than today to move forward with a package, and reparations is just one part of that. Thank you, Jonathan.
Well, thank you, Thomas, and again, thank you for the work that you're doing in collaboration with, as you say, with many of the people in this room. I think it's important, certainly outgoing from our working session yesterday, and the points that Peter has raised, and that it's a collaborative effort. We need, IOM has said they need partners. They need partners on the political level, on the international level, but they also need partners in the country to band together and speak as one voice on the issue of reparations. These are, we're not talking about specific categories, as our colleague mentioned. It's not only about this one category, that it's also about the human losses, those people who died during the war, those who were killed. These are all issues that have to be addressed. And it's not to favor one category of victims over the other, but to join efforts in recognizing and acknowledging the human losses and the suffering that took place during this conflict. I have to conclude the panel now. I hope also in the way we designed it and we talked about it, that it was in some way a collaborative effort as well. And I think, as our colleague Peter van der Ouweraert has said, this is a beginning of a discussion which will hopefully take place on many different levels. So I think you will be seeing, hopefully, our IOM colleague coming back to the region, meeting again with you to explain where they are in their negotiations around these efforts. There are several people in this room who are representing civil society organizations. Your support will be key to this, as we heard from our colleague from HL's Humanitarian Law Center, and of course the victims associations, but also the international organizations, our colleagues from the UNHCR and also the European Union. I think it is an issue that has to do with the future of Europe, how the victims of war are treated and how they're respected in the post-conflict period. So thank you very much for attending this session and for your contributions to our deliberations. And we hope to see you again soon in a slightly different configuration.